Hello everyone, welcome to iQuanta. My name is Sheva Khan and I will be your faculty for legal reasoning for CLAT UG exam. These are basically small concepts videos, and the first one that we are going to study today about is the stages in commission of crime, which is a primarily very important topic when we study about the criminal laws in the country. Okay, so let's begin with the first concept. Basically, we need to understand what is crime. We generally use the word crime, somebody has committed a crime, somebody is a criminal and everything of that sort. But we need to understand, as per in the eyes of law, what exactly do we mean by crime? So here there is a very small definition of crime which says commission of an act that is prohibited by law or an omission of an act that is obligated by law. Basically, when we try to understand, there are four words, two of which fall with each other. Commission comes with something that is prohibited by law, whereas omission comes with something that is obligated by law. Basically, if you do something that has been stopped or prohibited, or that the law has asked you that it is prohibited under the law, the commission of that particular act would be a crime. An example of this is murder. Now, of course, we all know that no law would be one that would allow murder by any single individual, right? So if you're committing something that has been prohibited by law, you will be committing a crime. Now, what do we mean by doing something or omitting from doing something that has been obligated by law? That is also a crime. I know it might come as a new concept for you, but let me give you an example. There is a swimming pool and there is a person who has been appointed as a lifeguard over there. Now, he is under a proper legal duty to save somebody who would be drowning in this swimming pool. So there was something that he was obligated to do by law. But what he did was that a child was drowning here and he did not do any efforts whatsoever to save the child. So basically, he omitted from doing a particular act that was obligated upon him by the law. So if not doing this over here will also be a crime? Yes. So now I hope you have understood that we have to do do something that is prohibited by the law, or we have to not do something that has been obligated by law, and it will amount to as being a crime. Now the next is generally, of course, it will be the disobedience of law. So in all, if you're not following what the law is saying, or if you're doing something against what the law is saying, that will be called as disobedience of law. In India, there are two major books basically, or major ideas or major types of laws that we have. First is under the IPC, that is the Indian Penal Code 1860, and the other is the Criminal Procedure Code under 1973. When we talk about the laws under the IPC, these are called as the substantive laws. Now, by substantive laws, we mean that under the IPC, the definitions, the meanings of these laws have been given. For example, a murder could mean something else for me and it could mean something else for you. Now, of course, somebody has to lose their life for a murder, but substantially it would mean differently for different people. That is why, to avoid any such kind of kinds of confusions in the long run, IPC defines as to what a particular crime would mean. Robbery has its own definition, theft has its own definition, murder would have its own definition, culpable homicide would have its own definition getting. So the punishments as well as the definitions basically, as well as the punishments for these have been defined under the Indian Penal Code, and this forms the substantive part of the law. But when we talk about the Criminal Procedure Code, the name itself is deciding. When we talk about the Criminal Procedure Code, the name itself defines that it would mean the procedure that would be followed so that the laws given under these, or the IPC and various other smaller criminal laws also, they can be followed properly, right? So Criminal Procedure Code is a procedural law, and that is why all the procedures to be followed have been given under this. Now, as a general understanding, we should understand that criminal law in India has two segments. One would be the substantive, that is the Indian Penal Code, and the other would be the procedural, that is the Criminal Procedure Code. Now, when we talk about the stages in crime, so here a crime has occurred, okay? This is a crime A that has occurred. Now, of course, for this to take place, some steps need to be followed, and only then we would reach upon the crime A. So there are some stages of crime that are important. The first one is intention. We will deal with them in very short, crisp detail in the further slides. And the two important elements of intention are mens rea and actus reus. We'll discuss them as well. then we need to prepare in the line of this intention, then we need to take an attempt, and if that attempt is successful, then it is called as the commission or accomplishment of that particular crime. One thing I would like to tell you, everyone, that whenever we use the term commission of a crime, please also mean that under this only we also mean the word omission. Remember, we were discussing about commission or omission, and they both will constitute as a crime. So please do not be confused that we are not using the word omission, so it would not be included. In general, we use the word accomplishment or commission. All right. Now, when we talk about the first one, that is the intention. Now, why do we say that, we have an evil mind, the human has an evil mind? Because everything, the preparation of everything, good or evil, starts in our mind, right? So the first stage is the building of intention in our mind, okay? So the criminal liability of a person arises only when he has a malified intention. Now, this is very, very important, because criminal, a person to be called a criminal, or by a court to be declared as a criminal, or an act also in particular to be called as a criminal act, what was the intention of that person while he was committing that act? Was he really criminal minded? Did he have something negative in his mind, or some negative gain to be gotten from that particular act? Or was he actually acting in a bona fide thing and it turned out to be a crime? This needs to be considered. Okay, I'll give you an example. For example, there was a child who did not know that there is poison in a particular bottle, right? Now that child simply gave it to his friend that it might be something to eat or drink. The intention of the child was not to kill the other kid, right? What was the intention? To maybe just share something with a friend of his. But ultimately, the other child got poisoned. So definitely the person was harmed, maybe, God forbid, but that child also died. But we need to consider that what was the intention of that person doing so. Now, me, for example, if I take a bottle of poison and I know that this is poison and it can harm the other person, and still I decide, I choose to feed it to some other person, definitely my intention is malified, right? So in that situation, we will be criminal minded, right? I would be criminal minded, not we. But yeah, though I'm not, all right? So here, the next one is the motive needs to be considered. So definitely we need to understand that in criminal law, intention and what was your motive of committing a particular act, and was your motive malified, that needs to be considered, okay? Then we have is that mere intention shall not constitute a crime, as it is impossible to know the intentions of a person. Now, of course, had it been possible, everyone, just imagine, had it been possible to read a person's mind, the judgments in the courts would have become so easy, right? But unfortunately, that is not the case, and that is why just having guilty intention is not enough for an act to be called as a crime. You or a person must have acted in furtherance of that malified intention, and something must have been done in reality, in the physical world, in order to make it as a criminal act. Getting? We'll understand that further or in a greater detail when we will be dealing with next stages. So here, as I said, there will be two aspects of intention. One is the mens rea and the other is the actus reus. So mens rea, nothing, only the guilty mind. Exactly what we just studied, it is called as the mens rea. So all in all, nothing much. All of this can be concluded in these two words, that is mens rea. If you had mens rea, which means you would have had a guilty mind, right? So a person committing the crime is mindful of his actions and knows that accomplishment of that act would result in a crime. As I gave you example of feeding somebody with poison, knowing the effect of feeding a poison to somebody else, all right? So if one person chooses to do that, he had mens rea or he had guilty mind, right? When we call upon, or we talk about the actus reus, just do not ratificate anything, just look at the word act, right? This is exactly what we're talking about. When you act in furtherance of this guilty mind, that is called as the actus reus, right? And I already said that whenever we'll be using commission act, we will also be including the term omission, right? So act or omission on part of the person which causes a crime and involves some physical activity, as we were discussing, right? Now the next one is preparation. Now, of course, when we think something, we also tend to do something for that, right? If I am thinking to shoot a person, I will definitely be buying something, or maybe I'll already have a revolver or something. If at all, if I don't have it, I'll be buying it, right? So whatever we are thinking in the mind, like if this is my mind, I need to do something, some preparations in order to bring it into action, right? So an act that is in furtherance of the malified intention of a person will be called as the preparation, and an act shall be a means to the attempt and accomplishment of the crime. And through these particular actions or these particular preparations, you would have been able to achieve your negative malified intention. So that would be called as the preparation, right? So illustration is that A purchases a weapon and carries it with himself shall amount to preparation of the crime. Like if there is no reason whatsoever and somebody had heard you saying, I will kill you, right? And very next day he goes to the market and he buys a weapon. So definitely it is in the furtherance of whatever he was thinking, right? Guilty he was thinking. Then general rule is that mere preparation of crime shall not be punishable. Now, of course, see, we need to understand that at times what happens is, I was very angry at somebody and I said, I will not leave you, right? And I even like prepared for hurting that person. But that doesn't mean that I actually committed the crime. Like, of course, I'm preparing to commit the crime. I'm still on stage 2. But have I committed the crime as yet? No. Right? So generally we need to understand that mere preparation of crime shall not amount to crime itself, or basically it is not punishable in itself. Reason is that it is nearly impossible to prove that the person accused had made the preparations to basically commit the crime. I could anytime, get away from my words. I was like, no, I was not buying the revolver to kill this person. I was just buying it for, at school. I wanted to carry the revolver. So definitely mere intention or just preparation is not enough. There needs to be another step that had to be taken place, and that step, everyone, is the attempt. So when we talk about the attempt, it is also called as the preliminary crime. Now by this, I hope you're understanding that basically attempt is almost, you've committed the crime, you're already on the preliminary stage of committing the crime, right? I'll also tell you that attempt, as we'll discuss over here, for various kinds of crimes is also punishable. So not merely that you had to accomplish it to 100% level. Even if you try to attempt that particular crime, you will be punished. So action in furtherance of the intention and preparation. Remember, stage number 1 intention, stage number 2 preparation, and if at all this plus this and you have gone for an attempt of a person to commit a crime is called as the attempt, which is also the preliminary crime. All right. Then we have that is attempt is also punishable under the law, and examples are, you must have heard it every now and then. You open the newspaper, open the news. Section 307 is attempt to murder, very, very common, which is in general also called as half murder, everyone remember. So it is the attempt to murder, 308 is attempt to culpable homicide, and 309 is attempt to suicide. I'd like to tell you a very fun fact over here that section 309 covers attempt to suicide. This is the only crime in the Indian Penal Code, the attempt of which is punishable, but if you accomplish it successfully, it is not punishable. Do you understand here? For example, if there was a person X, if that person attempted to commit the crime, then it would be punishable. Though different laws have come up for that, we'll discuss it in longer videos. But if at all that person was successful in the accomplishment and that person died, how are we supposed to punish that person, right? If one has already died, right? This is actually one fun thing or a loophole basically in the Indian Penal Code. Then we have is the difference between the preparation and the attempt is that did the act so done had any impact on the victim. This needs to be understood because until the time we were under only the preparation, no effect was there on the person as such, upon whom we were planning the crime, right? But as soon as we went on the stage to attempt, maybe we were trying to murder somebody, and in that attempt we just tend to hurt, but at least by hurting we have created an impact on the person, and that is why attempt also is punishable under the Indian Penal Code. All right. And the last finality is stage number 4, which is the commission. All right. So when an attempt to commit a crime is successfully executed, that is finality, and it is called that the crime has finally or ultimately been committed. Every person shall be liable for the act, offense or crime that he commits or accomplishes. Whenever you are using the word accomplish or commit, it can be used interchangeably while we are studying this topic. And at which stage now we need to consider the criminal liability arises. Now what do we actually mean by criminal liability is that if one person has committed a crime, right? So there will be some responsibility or basically anything, some punishment, there will be some outcome, right? some outcome of that particular act or crime that that person has committed, right? So that outcome, the bearance of that outcome, I will have to bear that outcome, is called as a criminal liability. So when will a person's liability for the act committed or the crime committed by him arise? किस moment पे वो शुरू होगा? This is, you like do not consider these answers for now, all right? Just try to understand on your own. At the level of accomplishment, when the crime has completely successfully been done, what do you think? Definitely yes. That is the purpose of having criminal law in the country, right? The attempt, as we discussed, section 307, 308, definitely yes. Now, preparation is something that is a confusing thing, because until now we studied that the preparation, mere preparation, is not punishable under the law, right? But in some cases, it is also punishable, okay? Like, for example, if we were planning or preparing to commit serious crimes like that of dacoity or waging a war against the government of India, in such cases, even preparing for such criminal activities is punishable under the Indian Penal Code, all right? So this was all for this topic, everyone. I hope you're clear with the concepts of stages in commission of crime. We will deal with some other topics in the next video. Thank you so much. Okay?